been withheld in this instance?
No, I don't think so.
Okay.
I think justice was done. You must try to make a distinction between the law and morality.
Okay.
The modern Slavery Act forbids what he did. So he was, in fact, pure and simple. You know, if you follow the case properly, you would find that it was a conspiracy to harvest organ. They planned it. Initially, he was his brother, who was a doctor, who had contacted Dr. Obita, and he came with the elaborate plan. And according to the judge, you can say that Ekweremadu was accused or was said to have known by deliberately staying one step away. So he never had direct contact with the boy.
Yes.
But he was funding it. So now, let us say he didn't know that it was particular Mr. Y who was the victim. Or he knew there was somebody who was selling an organ.
Yes.
Now, to sell an organ, to have a commercial organ transaction is a crime. So the judge said the boy did not have an informed decision. Even if the boy was properly aware of what he was going to do,
yes,
it will still be a crime. It will still be a crime. You're not allowed to buy an organ. Full stop.
And did the judge take into cognizance that Ekweremadu himself is a lawyer and should have known that it was
He did say that in his judgment. He said that he was the deputy president of Senate and he was lead person in the formation of a similar law in Nigeria. So he knew there was a law like that in Nigeria, which he helped to put in place. So he knew the implications of trading in human organs.
Why do you think the daughter was let off the hook?
The daughter was not part of the conspiracy.
Oh, I see. There was evidence to that effect.
Yes. So the parents said, we found a donor. Oh, thank you, Daddy. You found a donor. Oh, I'm so grateful. I'm so happy.
And it ended there.
Yes. And then she was asked to sign a document, an affidavit, to say that the donor was her cousin. And I told her not to sign it. And she didn't sign it. Now, that was adduced in evidence as in the trial as evidence of Ekweremadu not conspiring with anybody. But the judge said, well, that in itself is evidence of him staying one step away. Making sure neither he nor his daughter committed perjury by signing a false affidavit.
I see.
So she didn't sign the affidavit, she didn't know the victim, and she never particularly told anybody that this person is my victim, is my cousin.
My cousin.
Yes. So the daughter was not part of the conspiracy, even though she was to be the beneficiary of the organ.
Do you find it is there anything that protects the victim? That's the gentleman. But I'll tell you this, my major concern is for the victim, not for any other person. Because he's the victim, his life would never be the same again. Some people might look at it to say, okay, he has an opportunity to go to the United Kingdom, and I say, so what? That is not a guarantee that his life is going to be better. To be honest with you, in fact, his life could take a turn for the worse. So what protection does he have under the law now, the victim? Remember, he's 21.
Yes. He would just be protected like any other victim in the UK. Society protects us. We have the police, we have law enforcement agencies. He will be granted asylum, I believe.
Okay.
And once he's granted asylum, then he could live here and protected by anybody. If he is very, very worried, or if there is evidence that his life is in danger, it could be put on like a witness protection scheme. We have witness protection schemes where he'll be given a new identity.
Yes.
And relocated somewhere and you would know. It could even be obese. It could be the US, Canada, Australia. You wouldn't know. With a new name, new identity. If it's no weakness, but if his life is in real danger. But I don't think it will go that far on this occasion. You never know.
But isn't it significant also that the judge had said that they had approached him to ask if he wanted any monetary compensation, and he turned it down?
Yes, it is. It just goes to show that he wasn't in it for the money.
Okay.
There is what we call a compensation order, especially where the convict, the accused, is in a position to make to pay a compensation order. So the judge would look at what the victim has lost and the injury to his feelings and other things, and then order the accused or the convict to pay a sum of money as compensation to the victim.
How much would it have been?
And
just for us to have an idea.
In this case, it could run up to £100,000, maybe, or slightly less.
Really?
Yes.
Good.
Yes, because he would look at the fact that he was removed from his base, put into a place where he knew nobody, nothing. The possibility of starting a new life, what he has lost, and the trauma, the psychological trauma he has suffered. So it could be especially, and then the judge would look at the ability of the other party to pay, of Ekweremadu to pay. So it could go as much as that. Yes.
Well, if the judge said that Ekweremadu had about 40 houses, I'm sure they would think they could pounce on one if they need.
I'm sure.
Do you think did the guy have any legal representation though?
He didn't need legal representation.
So who would have advised him not to take the money?
Well, police officers were there with him. They went to see him. So I'm not sure he had anything. But if he had legal representation, the lawyer wouldn't advise him not to take the money. Matter of fact, the advice would have been take the money. So I think maybe it was a decision he made himself.
The court, the matter has gone on appeal, I assume. Am I right?
Well, I've heard people say it's gone on appeal. Well, I've not seen anything that shows it's gone to appeal. Appeal is not automatic.
Oh, I see.
It needs to get what we call a leave to appeal. And what is he appealing? Is he appealing the sentence or is he appealing the conviction? So if he goes to appeal, first there's a conviction, then there's a sentence. If he thinks the conviction was wrong, then he appeals the conviction.
Yeah.
He would have 28 days from the date of conviction to put a leave for appeal. Now, appeal is technical. Appeals are technical here. You don't just say, I disagree with the court. No. You have to appeal on the point of law. So it was a jury conviction. A jury convicted him. A jury of his peers, ordinary people who heard the thing. The jury is the absolute arbiter of facts. They come up with what they call the findings of fact. We found that the accused did this. That is a legal fact, which is immutable. You cannot change it. So if the jury found that he did these things, what is he appealing? What is this ground of appeal? You can only appeal if you say there was a case where the judge misdirected the jury.
Okay.
There's a legal technical point there. Or if the jury had tampered with. There is a legal technical point there.
You find that people have been highly emotional because of the Nigerian attitude that an important person must suffer nothing. And they've called on the government, they've got former heads of states to write in, they called on the government and so called on the government to do something. Let's take the government on from the very onset, because Ohaneze was saying yesterday in the statement that the government didn't do anything in this case. What could the government have done?
Nothing.
I'm glad I'm hearing that from you. I thought so too.
We have an independent judiciary here.
Okay.
And the government, neither the British government or foreign government, can influence the judiciary. The judiciary will do what it believes to be right. If an error is made, we have the mechanism to correct it. Now, yes, people are allowed to write in mitigation,
Okay.
But the judge will take the mitigating factors and the aggravating factors into consideration when he gives his judgment. So they can write, but there's nothing the government can do, the Nigerian government. There's nothing.
I'm of the impression, and I'd like you to correct me, that the flurry of letters and comments also complicated Ekwerimadu's case. During the trial, the caliber of people, the Senate visited him, they did this. Don't you think this will spark something in the judge to say, but this man should know he's so important, and that I will use this, his own case to teach other people a lesson. Do you think
it is possible, but the judge was not allowed to say. He wouldn't say that.
He wouldn't say that. No, but
he wouldn't say that. But it is possible. Yes, it is possible. But if he said that, then
no, he wouldn't say that.
He opened the door for an appeal.
I know,
because as I was saying earlier on, you can appeal the sentence separately. So you can say, okay, I accept the conviction, but the sentence is too harsh. So we will say it is manifestly excessive. But in this case, he was in the category B, and the lower end of category B. He got 9 years and 8 months, which means he was at the lower end of category B. If it were category A, it would come from 15 years to life.
Wow.
So he got the lower end of category B. I can't say him saying that is harsh. So before you appeal, you have to seek a leave to appeal, and then you have to state the technical points, and a judge would have to grant that leave before you put in an appeal. So maybe there's a notice of leave to appeal, but I can't say the point of appeal here. I don't say the legal point that he wants to appeal on. I wait to say the magic his lawyers will do.